Afternoon, everyone. I'm going to start the meeting so that we don't have to listen to the background music over there. And before we start, I'm going to ask Senator Burns, what's your mic number? To open us in prayer.
If you would, please, join me on a Friday afternoon. Father God, we're grateful. We're blessed. We're blessed to be here on a Friday afternoon because it is important that we consider the challenges that our children and our families face. We appreciate this committee. We appreciate those bills we'll hear today, and we ask that you give us your wisdom and your guidance as we work hard to do your will. In Christ's name I pray. Amen.
Thank you, Senator. This is getting to a very busy time in this session, and so we are trying desperately to get all the bills out that we need to get out because Monday is the deadline. And so that's why we're here late on a Friday afternoon. And just so everybody knows where we are, we've got a couple people in other committees that'll be showing up. And we have a hard stop at 3 o'clock because there's another committee that starts meeting at 3 o'clock. The chairman is sitting there, and I'm on that committee too. So we're going to have to keep things as short as possible. We do have sign-up sheets for both of our bills. So if you want to testify and did not get to sign the sign-up sheet, just walk on up here, and we'll make sure that you have the opportunity. We have two bills, and we're going to start with Senate Bill 245, Senator Hodges, and then we'll hear Senator Brass's bill, Senate Bill 259. So, Senator, come on up. The floor is yours.
Thank you, Madam Chair. This is the first time I've ever been in front of your committee. I really appreciate the opportunity to be here, and we will try to be brief. Colleagues, I bring you Senate Bill 245. It is the Grandparents Visitation Bill. I'm working off LC number 570150. Very quickly, what this bill does, it amends 19.7.3 of the Official Code of Georgia so as to include grandparents within the category who may seek to revoke or amend an existing grandparent's visitation order. That section relates to action by grandparents or other family members for visitation rights for intervention. Like so many bills, this bill was brought on by one of my constituent issues. Linda and Steve Smith, who are my constituents, are from Macon, retired to St. Simon's. They had a grandchild by their son and his wife, and their son died. And for reasons that I won't get into and they can discuss, the Smiths wanted to change their visitation rights. They found out that as grandparents, they had no standing to modify their rights that had already been established by an earlier order. They actually found that this section 19.7.3 was silent on the issue of grandparents. So this bill that you've got in front of you attempts a correction by amending section 19.73 by revising subsection C and D. Subsection C adds the word grandparent to a list of legal, custodian, guardian, or parent as able to petition for revocation or amendment of existing visitation rights. That's line 38. And as the existing law says, but that can't be done more than once in a 2-year period. Currently, as the law is written right now, on D line 1, or excuse me, D section 1, section D1, on lines 59 through 61, the law addresses a situation if one of the parents dies, is incapacitated, or incarcerated. And the current law, before we do this, says the court may award the parent of the deceased, that would be the child's grandparent, reasonable visitation during the child's minority. This bill amends that language on lines 64 to 68, adding that after such visitation rights are granted to the parent of the deceased, incapacitated, or incarcerated, in other words, rights are given to the grandparent, then that grandparent of the minor child may petition the court for revocation or amendment of those visitation rights for good cause. Obviously, the court in its discretion may grant or deny, but again, you can't do that more than once in any 2-year period. I acknowledge that Georgia law does and should defer to parents of children about visitation rights. We believe that parents are best suited to take care of their children and figure out who they should visit with. But I don't think that the law as it was written meant for grandparents to be shut out after particular circumstances happen, and then they're not able to go to court to try to get existing visitation rights changed. And I want you to remember that if we do this, that a judge would hear facts and would make a final determination of visitation rights, and remind you also that this bill would do nothing at all to change the standards by which a judge might rule on that. James Bill helped with the preparation of this, and I'm not a lawyer. I'd say that the closest I've ever been to legal experience would be my first term, 2 years on the Judiciary Committee, and quite frankly, I don't think that helps a whole lot. But James is a very good attorney, very knowledgeable, and can answer any legal questions about it. I yield for questions.
Okay, you do have one question, Senator Mella.
Thank you, Madam Chair. To my good friend from on the coast, we had a conversation earlier in economic development. We talked about those silk stocking law firms. Would you contend would it be your opinion that Mr. Bill would then be one of those silk stocking lawyers that we talked about?
Not today.
Okay, Senator Payne.
Thank you, Mr. Chairman. Just say that having worked in juvenile court for 30 years, I know this is an issue that comes up every once in a while, and I know that I have seen it multiple times in my 30 years. So I just say thank you for bringing this piece of legislation.
Thank you, Senator.
Senator Burns.
Thank you, Madam Chair. Help me understand, just for clarification, I certainly support grandparents having this opportunity. Would this presume that the child is living with the parent of the either deceased or incarcerated individual? In other words, the child would be living with a parent. Is that correct?
That's correct.
Mm-hmm. And so what we have is grandparents on both sides of the family seeking standing in order to gain visitation rights. Is that correct?
As the law is written now, parents, guardians can petition to change the visitation rights. Grandparents can't. And
That's correct.
And I believe that was just, I don't know, I wasn't here, but I think that was probably an oversight.
May I share an experience with a constituency?
Sure.
I have a constituent whose daughter-in-law unfortunately died tragically in an accident. Their son, unfortunately, is incarcerated, and the grandparents are now essentially the son's grandparents are the responsible party for the child, but they're sharing visitation with both sides. And so my question is, in that case, grandparents on either side would have standing. Is that correct?
I believe in that specific situation, it sounds like there's one set of grandparents that probably have custody of of their grandchild. So the other grandparents, they would be seeking some sort of visitation, right?
All right, thank you.
Okay, any other questions from the committee? We have several people signed up to testify, so if you guys could just step aside and let our other witnesses come up. We'll start with Steve and Linda Smith.
I'm Steve Smith.
Welcome to the Capitol.
Thank you,
Thank you,
Go
Madam.
right ahead.
Linda. And we're
Pull the mic close to you.
very proud grandparents. And I'll assure you, we're not gonna try to be brief. We are gonna be brief.
I've said my
We've
time.
made bullet points here. I want to thank y'all for allowing us the opportunity to come and present to you. This is something that has troubled us since we discovered that the law was written so that it would not allow us to appeal to the court, because we are grandparents and we do currently have grandparent rights. We've had our grandparent visitation rights since 2015. My wife and I are retired educators in Georgia. We've served the public school system in Georgia for a total of 72 years. We know about children, and we know working with children, and to last for 72 years between us, we'd have to love children, and we do, and we love grandchildren. We have enjoyed grandparent visitations, as I said, since 2015. Never missed an opportunity to visit with our granddaughter in this case. We ask for your support of Senate Bill 245 because we think it was an unintended consequence that grandparents were left out of this bill. I can't imagine anybody wanting to leave grandparents out. I think it was definitely an unintended consequence. So I'm not going to talk further in the sake of time. My wife is, she knows this probably better than I do. So Linda, if you would, just tell our story.
Thank you again for your time and your consideration. On August 10th, our son died of a massive heart attack while I was trying to do CPR, and our granddaughter called 911 and was outside looking for the ambulance. Our granddaughter, having experienced that horrific time, was not allowed to attend her father's funeral. And also, when we went to obtain our first court-ordered visitation in August, our ex-daughter-in-law did not show up, and we summoned the police and got a report, and then hired a lawyer to seek our visitation. Our ex-daughter-in-law was maintaining that since our son had died, we no longer had grandparents' rights, so we had to have legal intervention. And we have seen our granddaughter a total of 3 times since August, and missed birthday and Christmas as well, because and we've had to have our lawyer seek intervention each of those 3 times. And when we found out that we could not go before a judge and ask to have those laws amended, our son had had our granddaughter for 3.5 years because of issues related to her home life. And so we assumed when she went back and then he died, that we could be able to achieve some of those visitations that he had had, because he had her roughly every other weekend, half the summer, but we currently had 4 times a year as well as a weekend of summer, and those were granted in 2015. We never once missed a visitation. We were always on time, and we have tried to provide to our granddaughter a stable and loving environment. And by you listening to us now, we just ask for your consideration on this bill, because it's the judge who would decide, and we just wanted to get in front of a judge to see if we were worthy of additional time with our granddaughter.
Thank you very much for both of you for sharing your story. We have one other person to testify, Gary Graham. Come on up.
Good afternoon, everyone. I appreciate the opportunity to be here. I'm a divorce and family law attorney. I have been for 25 years. I've been chair of the family law section of the State Bar of Georgia, chair of the family law section of the Atlanta Bar of Georgia, member of the American Academy of Matrimonial Lawyers. Practicing divorce and family law is hard in and of itself. And as a lawyer, I have 3 top cases that will bother me till I go to my grave. And one of which is the Namdar versus Namdar case, which was a grandparent visitation case in which the grandparents got established visitation after their son tragically passed. The visitation schedule was somewhat ambiguous to the point where it allowed mom to manipulate the schedule to the point of when the grandparents came to see me to represent me, they had absolutely no contact with one of their grandchildren. Previous to dad dying, they lived pretty much right next door to each other. The grandparents had an established relationship. The grandparents financially contributed to their grandchildren. Dad passes. Mom moves in the middle of the night to Cobb County, Georgia, and gets the visitation schedule in New Mexico that is since transferred here to Georgia. So at the trial level, we were seeking to modify their existing visitation to take into account mom's basically frustrating to the point that the schedule had no worth, not even on paper, frustrating their time. And the biggest way she did that was what's called alienation, where you alienate a child against a parent or a grandparent, and the child just wants nothing to do with that parent or grandparent. So we file modification of visitation in Cobb County, have a guardian ad litem appointed whose job is to represent the best interest of the children, who finds, yes, mom's alienating. And alienation is so bad to the extent that one of the grandchildren had nothing to do with their grandparents. The other grandchild, it was more of a strained relationship. And so 2 years in litigation, we have a final trial. The trial judge modifies the visitation to take into account mom's, I'm obviously not very objective, mom's despicable behaviors, and addresses and modifies the visitation accordingly. The appeal, where, as we just heard, I don't know if it's an oversight, I don't know if it's more deference to parental rights than grandparent rights, but under the current statute, grandparents do not have a right to modify. And in this tragic result, they desperately needed that right to modify, and they didn't get it. And frankly, what is the point of giving grandparents the right to have visitation in and of itself if you can't modify it to address what's best for the grandchildren, the parent, and the grandparents? And so while this case was very tragic and will sit with me forever, I urge you guys to allow grandparents to modify their visitation. Otherwise, they can get visitation, and it can become meaningless if they can't go back to court at their own initiative to modify and address whatever problems may be existing. So I thank you all.
Thank you for coming to the children's version of the Judiciary Committee. Okay, I'm going to ask Senator Hodges to come back up, and James, if you want to come with them and see if the committee has any other questions for you.
Can I add that I believe that each of you have the case that he was just talking about. You should have a copy of it in your folder. And this is the case that was cited when the Smiths were denied an opportunity to go to court.
Thank you. I'm not seeing any questions. What's the will of the committee?
I move do pass. LC 570150.
Okay, second, Senator Payne. Okay, any further discussion? If not, all in favor, raise your right hand. Okay, it's unanimous. Thank you very much. Your bill passes.
Thank you, Madam Chair. Thank
Luck
you,
and
committee.
rules.
We appreciate it. Y'all have a good weekend.
Okay. Our next bill is Senate Bill 259. We've got the powerful Rules Chairman, Senator Brass, who's going to present. And again, we do have people signed up to testify, so okay, Senator Brass, the floor is yours.
Thank you, Madam Chair. So I want to rewind to about a year and a half ago. I got a call from a constituent, and he was a former acquaintance, knew him from the golf course from my prior job. And he called me from the hospital. He had been removed from seeing his grandson Ridge. Ridge was, I believe, just about a few months old at the time. And Ridge at birth had some complications at birth and caused some issues around the brain, and was having complications, and was taken by his mother and father to the local fire station for help. They ended up life-flighting Ridge up to Choa, where Ridge was then, treated to save his life, first off, and then second was evaluated for potential child abuse. And at the determination of the doctor, they found that they determined that it was, I believe, shaking baby syndrome. And at that point, the parents and grandparents were not allowed to see him at the hospital. Well, fast forward through the process, and the grandfather called me. We had a prior relationship, and I could just hear the terror in his voice, and I really didn't know what to do. And I did make a call to my mother-in-law, who was a DFAC SAG, and kind of asked her about the process and what goes on. And after speaking with her, I called him back, and I was just honest with him, and I said, look, you need to let the process take place, because as bad as this is right now, you'll feel worse if there's someone out there that is abusing this child and you just don't know it, and we lose this child. So let the process play out. It's going to be awful, but let it play out. Well, when I told him that, I was thinking this process was going to be a few days, maybe 2-3 weeks. Well, Ridge was taken from the home for 15 months, and they ended up they hired lawyers, of course, and hired other doctors, medical professionals to come in and prove in court that this was not abuse. It was all from his previous medical conditions at birth. And the good news is Ridge is back home. They won the case. Ridge has been back home for now just a few months. But for 15 months, because of a mistake was made, a family was potentially torn apart. And so that is the purpose of this legislation. What we found in that case was that the child's records were not, his previous medical records were not reviewed. And I'm not after this doctor. I don't know that they did anything wrong, but the symptoms were, they're very similar in what happened to him at birth and shaking baby syndrome. And we all make mistakes in everything we do. Human error will always be a part of life. But unfortunately in these cases, human error can tear a family apart. And so that is what we're trying to prevent here with SB 259. It's the second chance law. And it's modeled after Texas, and they have a very similar law. And simply what it says is when the child is taken into temporary protective custody by a physician treating this child, it requires the physician to advise the parent, guardian, or legal custodian of the right of an independent medical evaluation or specialty consultation. So that would allow them, the family, to hire. It would be at their own expense. They could hire a second opinion doctor to come in and evaluate the child and prove that their abuse was not there. It does also require the physician to fully disclose the basis of a determination of suspected abuse and neglect to DFACS at the time of the report. The other part of the law, it defines what specialty consultation is. You'll see that definition in the law or in the bill. It establishes the right to obtain an independent medical evaluation, as I've discussed, or a specialty consultation at the expense of the parent unless prohibited by a court order. And it requires the cooperation of DFACS, law enforcement, and the medical professionals with parents to facilitate the exercise of that right. It requires the juvenile court to consider the results of that second opinion, and it prevents the delay of the adjudication hearing if a dependency case has been initiated. Now, after Ridge was able to come back home, we the grandfather actually came up here. He had concerns over another bill that was in this committee, and I kind of walked him through. It turns out that wasn't gonna have anything to do with his case, and we understood that. And Commissioner Broche was here, and her, along with Regina Quick, our her legal counsel, they agreed to meet with my constituent, and we sat down, and they were very familiar with the case. I talked with Commissioner throughout the 15 months. She was closely following it, and one thing we like to, when we have a problem as a legislator, we always love it when constituents also come with a solution. And he suggested the Texas model of the second opinion law. And to Commissioner Broche's credit, she actually went ahead and did rules and regs around that went effective on February, I believe, 14th. I believe those rules and reg changes are in your file, and it does make it clear that the number one, the doctor has to review the medical records. If they did not, they have to report that within the SHINES program, and then it also states that the family has the right to that. I believe they have it, or we're handing them out. They're handing them out now. Sorry. So those rules and regs are being passed out now. I'll let y'all review those. I'm not going to recite them because I can't.
Can we just confirm the LC number, because there is a substitute?
Sure.
I've got LC 520821S.
I don't have any of it. I don't have
you
the
don't
sub
have
in
it?
front of me.
Come get it then.
So yes, Madam Chair, thank you for allowing me to do that. LC 520821S. We did, in consultation with CHOA, did make some changes to make sure under that specialty consultation that we were clarifying it is pediatric, in making sure that one of the specialties or fields is child abuse pediatrics. We had listed out several other specialties but missed probably the most important one. So they asked that we put that language back in, or put that language in. So we have added that in to make sure it's pediatrics. And then on the independent medical evaluation, actually is not defined, and that is done on purpose to ensure that they can, in some cases, they may need to bring second opinion from out of state. Because when it comes to who's certified in this state, my understanding is most, if not all, are located at CHOA. And many times when you're doing second opinions, you don't want colleagues, second opinion colleagues. So it was just a way to keep it clean. So with that, I'll yield for questions, Madam Chair.
Thank you. We've got several people signed up to testify, but before that, are there any questions at this moment for the chairman? Because we can also have questions after they testify.
Okay.
Okay. First on the list is Doris Good. If you want to come on up.
Good afternoon. My name is Doris Good. I am an attorney. 95% of my practice is representing parents who have been accused by children's hospitals of any type of abuse or neglect. My first case was back in 2009. One of our issues is for supporting this bill as a parent attorney is that anytime you go to the hospital and you get a wretched diagnosis, our natural instinct is get a second opinion, except for these cases. They're not allowed second opinions. What happens is that immediately the child is taken into care before we have any opportunity to talk to any doctors or see if there's any other evidence that we can present. We have no access to the child. We are allowed to ask DFACS for access to the child, which for many years never happened, never was allowed. At this time, we still are not allowed physical access to the child, only access to the child's records. If not, we go through the court system where we file a motion. We have been successful there in order to get access to the child, but it delays the process. My longest case was 3 years that the child was out of care of the parents by the time we finally got them. And all of my clients, I actually represented Ridge's mother, probably spent over $100,000 on these cases. It bankrupts the family, it bankrupts the children. It is our position, I think many of my colleagues I can speak for, that this is a good start to where we need to be on these cases. These families are torn apart, devastated, and they can't get that back time. So if you have any questions on the legal side of it, I'm happy to answer them.
Not seeing any questions. Thank you very much for your testimony.
You're welcome. Thank you.
Colleen Puckett. Thanks for joining us.
Good afternoon. Thank you so much for this opportunity to speak to you guys. My family came into the child welfare system Mother's Day weekend 2012. Our story is a little different in that our allegations were of medical abuse and not of fractures or physical abuse. A child abuse pediatrician and my daughter's feeding therapist were discussing, and they were the ones who brought our child welfare case and our allegations against us. Our experience truly was an example of how confirmation bias can happen in the child welfare system. Without speaking to our children, without examining my children, without speaking to my husband or myself, without a psychological evaluation of myself, and without speaking to my children's doctors, the child abuse pediatrician diagnosed my children as victims of Munchausen by proxy. And immediately that diagnosis was entered into their medical records before DFACS, CHOA, or anyone else had contacted our family. Immediately, my children were removed from my care and placed into foster care. Our second opinion would have been a psychological evaluation on myself. Had I received that, my children would not have either gone into the system or their time in the system would have been very shortened by what it was. After 13 months of my children being into care, I finally received a report from a psychological evaluation that I took. That psychologist spoke with me, spoke to my children's doctors multiple times, reviewed medical records, and being a psychologist who is able to diagnose mental health diseases, came to the conclusion that my children, in fact, were not victims of Munchausen by proxy. Their specialists also agreed that all their diagnoses were accurate and appropriate. After 13 months, my children were finally reunified after we received that report. From this experience, my children and I still have a lifelong trauma. We still have difficulty sometimes going to doctors and trusting them. And we pray that through our experiences and being able to share it with you guys, that we can hopefully keep that from happening from families that come after us. Thank you, guys.
Thank you, Ms. Puckett. Okay, also in favor of the bill, Bailey Collins.
Hey everyone, thank you for the opportunity for letting me be here today. I'm the mother of Rich Collins. It's still a little fresh, so I'm just going to read so I don't break down in front of everyone. Hi everyone, my name is Bailey Collins. I'm the mother of Rich Collins, and me and my husband were wrongfully accused of child abuse. Our case is closed. We won in juvenile court and our criminal charges were dismissed after it took a year to prove our innocence. This time I will never get back with my baby boy. He was only 11 weeks old when he was taken from my arms. My story is posted everywhere, so I will save you all the devastating details, but I am here today to tell you how important it is for this law to be passed and how different our story would have been had this law been in place. Our nightmare started on August 11th of 2023. My son was taken away from us, and during my son's first admission, we begged doctors for a second opinion to have someone else to review the records, to which a hand was put in my face and we were told it was not necessary. But me and my husband knew that our Ridge was never abused. Once taken away from us and out of our custody, our child's issues did not stop, which ended us in another hospital admission, and this time we were told by the neurologist that they had made a mistake, that this was not an outside of Ridge's body issue, that this was an inside of Ridge's body issue. So then started a further workup. A few months later, and after numerous tests, a review of his entire medical history and birth records, we found out my son was suffering from an undiagnosed medical condition, a very rare medical condition. Had this law been in place, the child abuse pediatrician would not have been able to get on the stand in juvenile court and testify that she did not review any of his medical history or birth records, and that she made her diagnosis solely off of the findings from the Children's Hospital. Had this law been in place, we wouldn't have had to spend over $100,000 hiring expert witnesses for that second opinion and hiring attorneys to prove our innocence. This law will protect innocent families, but not only innocent families like mine, but the innocent babies. It's innocent children being stripped away from its loving parents and subjected to unnecessary lifelong trauma. I hope everyone in this room today will truly think about the importance of this bill before making the decision to sign or not sign. My sweet baby boy never deserved any of this, and it could have all been avoided. This is why this bill is so important, and while there are still more changes that need to be made to protect innocent parents and children, this is a start. Thank you all.
Thank you very much, Ms. Collins. We've also got Kelly Holschuck Lopez.
Good afternoon. Thank you for having me. My name is Kelly Holschuck Lopez, and I'm here today representing my family, my husband Carlos, and our children Nicholas, Mila, and Benjamin Lopez. We are the Lopez family, and I want to share with you a story that changed our lives forever. It's a story about an unimaginable hardship, and one that could have turned out very differently if we had been given the chance to get a second medical opinion early on. Just 24 hours after my son was taken to the hospital, Children's Healthcare of Atlanta accused us of violently shaken or inflicting blunt force trauma. No evidence, no reports, just assumptions based on one fellow. They didn't care to look any further, including all medical records, inclusive of my labor and delivery, birth records, and pediatric. And with nothing but these false allegations, our family was torn apart. For 20 months, my husband and I were separated from our 3 children. Our family was broken, and we spent 5 long years fighting in court to clear our names, eventually leading to our charges being dropped. Not once during those years were we offered the chance to get a second opinion. Instead, we had to go out of state on our own to find the real medical truth for our twins. But even with the facts on our side, it didn't matter. Instead of an apology and reuniting us with our babies, we were punished. 10 months after the false accusations, my husband and I were arrested by a SWAT team, despite the clear evidence showing we had done nothing wrong and we were factually innocent. One of the experts in our case went as far as to say, I didn't need to look at any other medical records. I knew this was abuse. To me, this statement says it all. It shows how dangerous it is to make life-altering decisions based on assumptions without allowing the space for a second independent medical opinion. If we'd had that second opinion from the start, none of this would have happened. We hear a lot about acting in the best interest of the child, but in our case, That phrase was twisted and used to justify tearing apart our family. Instead of protecting us, the system failed us, and it failed our children. Our family has been irreparably harmed by the lack of access to independent medical expertise when we needed it most. This bill is about more than just a policy change. It's a lifeline for families who are in the middle of life-shattering accusations. It's about ensuring that no parent has to suffer through a wrongful accusation without the chance to get all the facts. It's about justice, fairness, and giving families the opportunity to prove their innocence when the stakes are so high. We were innocent, and eventually the courts recognized that, but this could have been avoided. If we had been allowed to get a second opinion from the beginning, our entire nightmare would have been different. I'm here today to ask for your support in passing this bill. No other family should have to endure the pain and devastation we did for 5 years. Thank you.
Thank you very much for your testimony. Okay, Senator Brash, you want to come back up?
So after they do the do pass motion, I'll offer the amendment.
Yeah.
But it's kind of a surprise to the family.
Okay. Any other questions for the bill author? Okay, anyone want to offer a motion?
Madam
Okay.
Chair, real quick, I do want to point out, and I should have pointed this out in my opening remarks, but you know, as you can hear testimony, it's devastating what happens or what can happen, and you know, CHOA sees over 2,000 of these referrals a year. I think 2,300 is the number I've heard. So, but every once in a while, a mistake is made, and this just gives us hope to prevent that.
Thank you. We've got a motion due pass by Senator Burns for LC 520821S, and a second by Senator Goodman. Okay. And are there any amendments?
Number 8.
Okay. Senator Hatchett?
Madam Chair, I've never actually been able to do something like this before, but I see there's 4 sections in this bill. I'd like to add another section. I've spoken with the author on this, and I would like to add section 1 to state that this act shall be known as Ridge's Law.
Ledge Council? So that would mean renumbering?
It would, Madam Chair.
Okay.
Also, to provide for a title, we would probably have to include that in the actual title language itself as well, to provide for a short title.
Okay. Got a second from Senator Mallow. Any further discussion about the amendment? Senator Brash, you're good with it? Okay. All in favor of the amendment, raise your hand. Okay. Nobody opposed? Unanimous. With that, we're going to vote on the bill as amended. And that, again, is LC 520821S. And we've got a motion to pass in a second. So all in favor, raise your hand. Okay, no opposition. Your bill passes. Congratulations. Good luck in rules.
Thank you.
And with that, we are adjourned. Thank you.